Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Today is Wednesday, July 30th, 2025. Wow, July's almost over. That went pretty fast, huh? That went pretty fast. I didn't know what to cover today. I had a couple of things in mind, so I just kind of put it up because a lot of people don't get notifications. And I thought, let me just put it up and then it'll be a game time decision on what we're going to talk about today. Hello, Auntie Deb's class. Good morning. Were you well behaved over there in summer school? How's everybody doing in summer school? I know you're reading the book of the yellow cottage cheese. And I was listening this morning because I had to go drop my car off for service. Because did you ever notice how everything in your house breaks in threes? It's always the three things that break at a time. Did you ever notice that? Remember my essential air was out the other day and I was sweating on Saturday. I looked very dewy, someone said. And then luckily I got someone in here Sunday to fix it. And now my dryer started beeping last night, and I don't think it's going to stop beeping, so I'm going to have to get a new dryer. But do you notice this, that appliances used to be so much better built than they are today? I think this dryer, it's a Whirlpool Duet dryer, like a big one, because I have a lot of kids. I do a lot of laundry. Front loader. I think I've had it for over 20 years. Like, that's how long these things last. And now you buy an appliance, they don't want it lasting 20 years anymore. Mercury's in the microwave again. They want you to have to buy a new appliance every 5 years. Like, I remember when I recently replaced my dishwasher too, because everything always goes in threes. Even the guy who was installing it, he's like, yeah, the one that I'm taking out right now that has lasted you for 20 years was a great dishwasher. They just don't make them like they used to. Right? It could be the control panel, but you know what? If I can buy a new one for $900 and I would spend $400 having a guy come and fix the control panel, it's like, why wouldn't I just buy a new one? I guess at this point, planned obsolescence. Yep. Ain't that the truth? The garbage. Yeah, the avocado green fridge. Everyone had one of those, right? Avocado green, and then there was that orange color. I don't even remember what they call it. An orange color. And also, remember the phone with the cord on it, like the avocado green phone in the kitchen that had like the super long cord, so you could like try and have privacy on the phone before call waiting. Does anybody remember that? Dating ourselves. Good morning, Auntie Deb's class. Yeah, they used to last forever, and now like Sears doesn't even really exist anymore. I don't know if all the Sears closed or if just the ones around here closed, but there's no Sears anymore. Was it burnt sienna? Was that the color? Harvest gold. Harvest gold, was that it? Yeah, the orange, and then the avocado appliances. Oh, that was so big. I know, it's crazy. Everything goes so quickly now, and everything goes in threes. And I have a car. It's a 2024, and Of course, it's still under warranty and I lease it anyway, but the transmission is slipping. Like that should not be happening on a nearly brand new car with 15,000 miles on it. I should not be trying to go up a hill and the car won't go. And then it's slipping and then it's just revving. I'm like, take it away. I don't want it, but I need a loaner because I got to go buy a new refrigerator. I mean, no, not a refrigerator. Praise be. That got fixed last week. The ice maker was down. It's a whole thing. It's a whole thing. The dryer is a Whirlpool Duet dryer, but I probably have had it for close to 20 years. So I feel like it's lived its natural lifespan. But I know that the one that I'm going to buy today or tomorrow or whenever is not going to last another 20 years. They're just not. Crazy. Yeah, no Sears. It's all gone. So what I'd like to do with you today, since we're getting into the Aaron Spencer case, and I'm happy a lot of other YouTubers are picking up on it too. That's great. The more exposure for the Aaron Spencer case, the better. I found the Supreme Court oral arguments fascinating. They're under an hour. It's under an hour. This was argued in front of the U.S., not the U.S. Supreme Court, the Arkansas Supreme Court on April 10th of 2025. They rendered their decision overturning that overly broad unconstitutional gag order of Judge Barbara Elmore on May 29th of 2025. But then Judge Elmore didn't actually vacate the gag order until June 20th of 2025, which is just a little over a month ago. And this trial is scheduled for a pretrial conference August 8th and trial September 22nd to 26th. So everything's coming up quickly. Because the gag order, we couldn't get any documents. Now we can. There's not a lot of documents, but I'm hoping they're going to be filing some motions, like maybe a motion to get the judge off this case. And that's what the Arkansas Supreme Court even suggested. They were shocked that Judge Elmore was the same judge that let Michael Fosler out on $5,000 bail. And perhaps the reason that he is now at the Endless Heaven buffet, as Kathy likes to say, is because he should have been in jail. Maybe, in my opinion. So there's that. So I thought we would do that. As somebody so kindly pointed out earlier, Emily Baker is having Bob Alessi on her show at noon Eastern. And so you're probably going to want to go watch that. So I was going to keep it short today anyway. But I just kind of want to point out for those of you in the back or who may not know, like just rules of etiquette. Let's say I invite you over to my house for a dinner party. And when you come over to my house for the dinner party, there's a bunch of other guests there. And you announce to all of the other guests that they should really go down the street to the restaurant for dinner because the food is better. That's just like kind of like, it's kind of like the same thing. I'm just saying. I do not want a Wi-Fi washing machine. No way. No way. No way. I don't want anything hooked up to the Wi-Fi because then when your Wi-Fi goes down, you can't even work your dryer. It doesn't work. It doesn't work. Thank you. Thank you, Grateful. Grateful. I saw it fly by for like in my hat. Somebody with Grateful in the name Grateful Little Farm. Thank you. And also to the viewer who I see in the chat now, who the other day was like trying to get the chat to believe that I was slurring my words and might have had a few. I don't drink, not even a drinker. So take a step back. And if I see it again, you're going to go bye-bye today. You know who you are. I don't need to name you. For the love of the traveling Mary. I have no idea why anybody would want a Wi-Fi washer or a Wi-Fi anything. I have a Dyson Airwrap that has like an app. I don't need an app to dry my hair. I just dry my hair. Right? Do I need an app? Yeah, I know. Kindergarten Cop. So yeah, you can't believe everything you read, right? So is this even true? Is it really National Cheesecake Day? Is that really a thing? I was all upset about the tsunami. I was worried about the tsunami, and then I was reading that Oprah wouldn't open her private road in Maui, and that people couldn't get out. And I don't know if that's even true. Is that even true, or do people just hate Oprah and so they're spreading that rumor? Like you don't even know it's true anymore. But praise be, I do not think there's been any damage yet, and hopefully will not be regarding this alleged tsunami warning that was for the West Coast and Hawaii. Because I know I have some friends from Hawaii in here, and I hope you've gotten up to higher ground. And I think Oprah's road did open eventually, and people were allowed to use it. So don't even know what's true anymore and what's not true. My sister was in Thailand for that tsunami. She was in, I forget where she was. If she was in Phuket, she was somewhere during the tsunami, and luckily, she happened to be awake when the water started coming up the beach. And it is, that was a very, very horrific time. And so I fear tsunamis. Amy Smith says, if your dryer has a tag on it, just call the company. They can diagnose it over the phone. You just hold your phone up to it. Oh, that's interesting. I feel like, though, you know what? I feel like it would be faster for me just to go buy a new. I don't know. I mean, I did the deep dive. I looked at the YouTube videos. I read all of the forums where like actual real repair guys come on and answer questions, and it's pretty much like, even when I unplugged it, this control lock button was still beeping. So I think it's just time. Thank you, though. That's a great idea, Amy. And Amanj, thank you so much for your super sticker. All right. So for those of you who do not know, oh, you lost coworkers at Phuket? Oh, that's terrible, Tina. That is so, she was not at the White Lotus. No, she was not. And this was what, 20 years ago, at least? For those of you who do not know, oh, they downgraded the Hawaii warning. Thank you, Sydney. For those of you who are not aware of the Aaron Spencer case, this is one that we need to keep screaming about. You know how I get. You know how I get when I get into something and I do a deep dive in it and I can't stop talking about it. Welcome. This is one of those times. Aaron Spencer is a 36-year-old combat veteran who lives in Arkansas with a 13-year-old daughter and his wife. I'm not sure if they have other children. That's not really relevant. This is just a basic overview. There's also a deeper dive underneath in the show notes below this video. Sometime in July of 2024, the 13-year-old daughter disclosed to someone that she had been SA'd, the R word, by a 67-year-old man in June. So it was about 6 weeks before she disclosed, which I will tell you from my work with survivors and victims and my lawsuits against the Catholic Church on behalf of many of the victims, 60 or so of them for clergy SA. It is very rare for a child to disclose ever. And so I am so happy that this child had someone that she trusted to tell that this was happening. The perpetrator, a 67-year-old man who was not known to the parents, had groomed her somehow. We're not really sure of the details. And so the Spencers did what any family would. They went to the police, the Lonoke County sheriff, and they filed a report. And eventually, the perpetrator, Michael Fosler, 67 years old, former law enforcement. He had been the chief of police in Hamlet, Indiana, many, many years before. I'm not sure how long before, maybe 20 years before or more. Was finally arrested, I think, sometime in July. Went to court in front of, it's the Lonoke Circuit Court, in front of Judge Barbara Elmore, and she tapped him on the wrist and let him out on $5,000 bail and gave him a piece of paper, a stay away order against the Spencer family and the young girl. Sometime in September of 2024, Michael Fosler waived arraignment and signed a piece of paper that he would promise to come back to court, and they set a trial date for December 2024. Shortly thereafter, on October 8th, Aaron Spencer and his wife woke up to the sound of their daughter's dog barking. And Heather Spencer, who's been very vocal now on Facebook since the gag order has been lifted, said that she told Aaron, maybe she's sick. Can you just go in and check? Aaron Spencer goes into his daughter's bedroom, and to his shock and horror, They call 911 and tell 911, our daughter is missing. Here's the guy we have a restraining order against who currently has 43 felony charges pending. Oh, I forgot to tell you that part. 43 felony charges pending for crimes against this girl, including the SA charges and many charges of pandering. We looked up the statute in Arkansas that has to do with materials that were found on his phone. Here's his address. Please go find out if she's there. Aaron Spencer grabs his keys. He gets in his car. He's panicked. He's driving around looking for his daughter and just so happens to come across Fosler driving his truck, his Ford F-150, with Spencer's 13-year-old daughter in the passenger seat. What happened next? There's some details, not a lot. Spencer, like, in my opinion, any good dad would, chased the vehicle, whipped it around, did a Yui, whipped it around. There is some conflicting information about whether he rammed the car to get it off the road and Fosler's car went into a ditch. He tried to get his daughter out of the passenger side and Fosler was pulling the girl back. Somehow a struggle ensues. Fosler gets out of the vehicle. Spencer somehow gets hold of his daughter and Fosler, the guy somehow gets in the ditch and grabs for something. Maybe Fosler thinks it's a gun, not really sure. Fosler pumps the guy full of lead, calls 911 and says, oh, by the way, I just called you a little while ago. And I found the guy and he had my daughter and you might want to go check on him. He's on this roadway. And he takes his daughter home. The same judge who let Michael Fosler out on $5,000 cash then is charged with arraigning Aaron Spencer. Originally, the DA of Lonoke County was going to charge Aaron Spencer with first-degree M, but landed on second-degree M. Same judge releases Aaron Spencer on $150,000 cash. Now he's forced to defend himself, to pay for counsel. And within, we spent 13 days, within 13 days, Aaron Spencer's attorneys had made immediately a statement to the press. Our client is innocent. He was protecting his family. He was protecting his daughter. I'm not sure exactly what they said. I'm summarizing. We are sure that the jury will find that he was acting not only in self-defense, but that this was justifiable, that the perpetrator, who, by the way, was out on a $5,000 bail with 43 felonies against his particular daughter, was kidnapping his daughter and would have committed a crime, and he was justified in what he did. And we asked for, the community support. We have a lot of support behind us, and we're sure that when all the facts come out, you will see that this was justified. Well, the judge didn't like that, and neither did the DA. So right away, the DA made a motion for a gag order, a very broad gag order. We read the motion papers, we went over the papers the other day. I think this is my 4th video on the Spencer case. And the defense argued in a 19-page, I think it was a 19-page response. And within 9 minutes, they asked for a hearing. There are some conflicting reports. Some say 30 minutes, some say 9 minutes. Within 9 minutes to 30 minutes of the defense filing the response to the motion for a gag order, the judge rendered a gag order. No hearing, just made a gag order. Not only couldn't the attorneys talk to anybody, neither could law enforcement, even law enforcement that wasn't involved in the case at all. The family was not allowed to speak. Anybody who may be called as a potential witness was not allowed to speak, and the defendant was not allowed to speak. Within 13 days. So while there was some media attention on this case when it first came out, and not only that, she also, in a handwritten note on the gag order, sealed the entire court file. So nobody could see anything. Luckily, somehow, Aaron Spencer and his family were able to afford the appeal on this to the Arkansas Supreme Court. Appeals are so expensive. I can't even tell you how expensive appeals are. The printing alone to print appellate briefs could cost tens of thousands of dollars. Yes, thank you, Robin, for reminding me. Fosler's trial was coming up in December. Like I said, she was the only witness against him. And do you think that if Aaron Spencer had not come upon them by happenstance that evening, that his daughter would have ever been home alive? I don't know. But I don't think so. Is he a criminal? Or is he a dad who is protecting his daughter and justified in what he did because this man was in the commission of a crime? He was in violation of the stay away order. But a jury may say, well, he should have just called 911 and waited for them to get there. We don't know. We've seen, what happens with juries and jurors. And this is an overcharge, in my opinion. There are several lesser charges that he could have been charged with. And I don't know Arkansas. I don't know what the jury pool is. I don't know what the makeup of Lonoke County is, but I know that this gag order was vacated by the Arkansas Supreme Court in a scathing decision, which we also read on another stream. But I thought it would be interesting for us to watch these arguments in front of the U.S. Why do I keep saying the U.S. Supreme Court? It's the Arkansas Supreme Court. How about no charges? How about no charges? Exactly. Look at Susan C. gifting 5 memberships. Thank you so much. They are randomly gifted by YouTube. I have no control over who gets them. So thank you so very much. Scott Robbins says, I'm part of a class action against my old Catholic high school. They covered up a bunch of stuff. Gross. That's terrible. I'm so sorry that happened to you. Kev, thanks for becoming a new member. And Mustafa's illegitimate son from Australia. Thank you for your 20. Says, this is vile. Many of us Gen Z were victims of grown men speaking to us at such a young age. Kick was the thing that had the most predators when I grew up. And I myself was a victim to that. Thank you, Melanie, for everything you do. Thank you. And I'm so sorry that that happened to you. And I heard that Discord is the new thing. Discord is the new way that people like that are going after kids. And it's revolting. And I am very I'm very against it. People have asked me to start a group over there. I'm like, why? Why would I want that? I need any more Discord in my life? I mean, just the name alone gives me pause. So let's listen to the arguments in front of Arkansas Supreme Court. These were held on April 10th of 2025. And if anybody is just joining, I mean, it's going to be scrolling along the bottom. So when they ask what we're watching, you can direct them to the little scrolly thing at the bottom. Okay. Oh, the Goodmans are here and they gifted a membership. Thank you. Thanks, Goodmans. Love you guys. The volume on this is a little bit low, so I am going to likely have to turn my volume down to match it. And I will do that. We will modulate the volume. What is the scrolly thing on the bottom about? That tells you it tells you what we're doing here. Tells you what we're watching, because so many people come in like, just got here. What are we talking about? Just got here. What's this? What's that on the screen? Okay. All right. Let's stick to facts. We're a facts-based channel, so I don't know who was friends with who or who knew who or who knew what, but I do know that Fosler used to be the police chief in Hamlet, Indiana. Yeah. All right. We'll modulate this. Just give me a minute. The problem is I know I can get an extension for my browser to boost a volume booster, but they do not play well with StreamYard. That's the problem. They just don't. All right. Let me know.
Are there any motions from attorneys or parties present?
No, Your Honor. No, Your Honor.
At this time, then, we will take up the oral argument scheduled for this morning. CR 2566, Aaron Spencer versus State of Arkansas from Lonoke County Circuit Court.
Okay.
And,
This is my volume.
petitioner's attorney.
So you want me to turn, I'm going to turn my volume down, okay? Hold, please. Okay, so this will be my volume and this will be the court volume.
Attorney to come forward.
Better, mods?
Ms. Casanelli. And you've reserved 10 minutes for rebuttal, is that correct?
Yes, Your Honor.
Okay. I just want to point out, Erin Casanelli is going to be arguing for Aaron Spencer. She is his criminal defense attorney, one of them. And I want to point out how rare it is for the trial lawyer in a criminal case to also be able to argue in front of the Supreme Court. Appellate attorneys are a special breed. It's a whole different skill set. The fact that she got up there herself and argued in front of the Arkansas Supreme Court is amazing to me. I was a partner in a very big firm and we always hired appellate counsel to do appellate work. It is very, very different. It is a very different skill set. So the fact that she's able to do it is incredible. Number one. Number two, yeah, she's doing both, which is amazing. She's very well spoken. I like her a lot. I'm going to try and contact her because I have questions. And even if she won't come on the show, maybe she can answer some of my questions so that, well, it wouldn't be a conflict of interest for her to argue the appellate briefs at all because he's her client. It's a conflict of interest for the judge. Are you talking about the judge, Christina? It's a conflict of interest for Judge Elmore to hear the case of Aaron Spencer after she's the one who left Michael Fosler out on jail. I absolutely agree with that. And when I looked up the circuit court of Lonoke County, First Division, it seems Barbara Elmore is the only judge in the First Division. She's the only judge. There's one judge, one court reporter, and one clerk or trial court manager. That is it. Maybe they got to get to another county. Okay, here we go.
You may proceed.
Thank you. May it please the court, counsel. I'm Erin Casanelli, and I, along with Michael Kaiser, represent Aaron Spencer, who's the petitioner before this court and the defendant in the court below.
There are no captions, sorry.
We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The law requires a careful analysis and a balancing of important constitutional interests when imposing a gag order. The law requires further a very narrowly tailored order that is specific to the case, the interests in the case, and the interests of the public in receiving speech and the parties in providing speech. This court, federal courts, the criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. In this particular case, this gag order is very important. This is an unusual case. I don't know how much factual information has been conveyed to this court, but it's unusual in several respects. Aaron Spencer is a father and a husband. His daughter was assaulted, sexually assaulted, severely, by a man named Michael Fosler. Michael Fosler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir. And thank you for that question.
Yes, sir. And I believe that is Nicholas Bronny. He is the one who wrote the concurring opinion. I've linked the full decision for you below. We read it on another stream.
You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fosler's criminal proceeding. And that's important in additional respects. There is no public record of his appearance that I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
That is outrageous. You should be outraged. There was no public record of Fosler getting out on $5,000 bail. No record of why, no record of who. Right? That is outrageous. Take that back a tiny bit. Oops. Took me back a little too far.
Gag orders should be allowed careful analysis, balancing
Mm,
courts. In this particular case, yes, sir, and thank you for that question. You caught exactly where I was going.
Was it the same judge who
Here we go.
issued the gag order was the judge in that case?
Yes, sir, and thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fosler's criminal proceeding. And that's important in additional respects. There is no public record of his appearance that I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question. We live stream our court proceedings, and
listen to this.
this is a public hearing. So, and it's live streamed. It's also saved on our website. Is that violating the current gag order?
That is an excellent question.
Great question. Great question. I've turned my volume down so that you can turn yours up. If you can't find a device that can work for you or earbuds, I'm truly sorry. There's nothing more that I can do.
And also on my list of things to discuss before this court, this gag order is so overbroad that I don't know that I can answer that question precisely. My belief is that this court has asked for this argument, and I cannot fulfill my duty to this court without explaining the facts and the law that apply to it. But the way the gag order is written, none of you could speak about the case from the bench here. The governor herself couldn't speak about the case if she wanted to. No public official could speak about the case.
Counsel, in preparation for the argument, all the court has 2 law clerks on staff, 2 attorneys. Were we in violation of the order when we were discussing it with our law clerks in preparation over the last few weeks?
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination.
And you could see from that question by one of the justices how ridiculous they think this gag order is just by the questions they're asking the attorney. Like, we could even be in violation of the gag order by discussing it with our law clerks and amongst ourselves, and by speaking about this because we're publicly recording this and it's going to be publicly disseminated. They think it's ridiculous too.
I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion that pertains to it. So I suppose arguably you could be. That seems outrageous.
So even if you assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him, and he can raise it presumptively as to counsel. But as to anybody else covered by this order, what standing do you have?
Yes, sir. There are several things that sort of fall into that category, but as a general matter, the overbreadth doctrine allows courts to consider First Amendment restraints that affect third parties. So I think that's discussed in the Murphy-Brown case, which cites a couple of Supreme Court cases for that point.
But for overbreadth to apply as a general matter, you have to first allege that this can be constitutionally applied to you. The reason why we conduct the overbreadth analysis is because it's constitutional as applied to you, but it's unconstitutional theoretically as applied to others. here, your argument is it's not constitutional as applied to you. So I'm a little bit confused how we get to overbreath.
Well, either way, I think it's unconstitutional as applied to my client, in part because it's overbroad and it encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases
Are there cases that treat overbreath that way? I mean, I'm not familiar with any Supreme
No,
Court
that's a
cases.
bit of a different doctrine. So think of all of the cases most of the cases that are out there involve the press, right? The press is coming forward and saying, we oppose this gag order that you have imposed that prevents all the parties from speaking. And the press is the recipient of that speech. And most often the defendant doesn't want the speech, but the press is still allowed to bring that motion. At times the parties bring the motion, but they are addressing whether they can speak and whether speech can be provided, for instance, in public records.
Then I guess my question is,
And remember in the Karen Reed case, how certain citizens of Norfolk County who wanted to picket or support outside the courthouse hired their own lawyer to go in and fight for their own rights about their own freedom of speech. That's kind of what he's asking here. Why do you have standing to bring this action or appeal this on behalf of other people that don't include your client? And she's got the answers, and she has to be ready, and she has to know the case law, and she's doing a great job. And I really, really like her a lot. Shout out to Erin Casanelli.
sir, if we found the gag order is unconstitutional to you, your client, is that sufficient, or are you seeking more relief? And that's why you've argued overbreath. Because normally, if we said it was unconstitutional as applied to you, the analysis would stop. There's a stack of First Amendment cases that say that. The analysis stops. Would you be satisfied with that relief, or are you seeking to invalidate the entire gag order? And again, what's the standing for that?
I don't think that the court has to go that far, because I think that it's unconstitutional as to Aaron Spencer, and that would cover all of the concerns, because there's really not a part of this order that is sufficiently clear, that indicates a substantial compelling interest, that's narrowly tailored. So I think that if the court decides that the order itself does not comply with constitutional mandates, then that is sufficient to get to the end, which is that it needs to be submitted back to the circuit court for a proper analysis.
So a slightly different variation in this question than what I took some of your arguments to be framed as. Yes, they were sometimes framed in terms of overbreath. I thought maybe you were making a facial challenge as to the gag order itself and just arguing it's unconstitutional in all of its applications. Am I wrong about that? Or?
That's a tough question for me to answer. I believe that it is facially unconstitutional, but I don't think the court has to reach that point. I think for purposes of our argument, pointing out the circuit court's disregard for the rights of the people that it encompassed in the order, and for the overbroad.
But that sounds like a facial challenge, right? That when you start talking about other people, if it's an overbreath challenge and we decide that it's unconstitutional as to you, the analysis stops. So you've either got to say it's a facial challenge or it's not really an overbreath challenge at that point. So which is it if you're talking about other people?
Well, the point that I'm trying to make is I think that is important evidence of the order's overbreadth and the problem with the circuit court's lack of analysis.
Okay, it's overbreadth, B-R-E-A-D-T-H, and that means something that is overly broad. That they're arguing that the gag order was overly broad because not only does it, gag attorneys, public officials, the family, potential witnesses, anybody who could be subpoenaed. That's what they mean. Overbreadth, B-R-E-A-D-T-H, overly broad.
I think that
Counsel, what I thought I heard you say earlier was that it wasn't just that you're arguing that prohibiting the defendant's speech, it was his receiving speech as well. And is that why it in a sense, you're arguing it's unconstitutional, the restrictions on others is because it prevents them from him receiving their speech?
Your Honor, thank you, Justice Wood. My point there was just that the First Amendment protections are both as to recipient and speaker. In this instance, our position is that Aaron Spencer, the attorneys, the people that represent him, his family, any interested party should both be able to speak and have access to the information necessary to speak. So, for instance, closing all court records. And by the way, there were no court records made public. So even the affidavit of arrest or the charging document aren't public. But he has a right to access those records and share them with other people. That is speech.
That seems to be slicing it, I mean, putting
Wait, hold on.
too much emphasis on one point. I mean, court seal records all the time on one, seems,
And share them with other people. There were no court records made public. So even the affidavit of arrest or the charging document aren't public.
Yeah, that's wild.
But he has a right to access those records and share them with other people. That is speech.
that seems,
We still can't get Michael Fosler's records. All we can get is a list of the charges, 43 felonies that we went over together. Can't get any of the documents on it. Court sealed them. They could have been redacted, but the court said, oh, it's just because it's a minor. Could have been redacted.
seems to be slicing it, I mean, putting too much emphasis on one point. I mean, court seal records all the time for various reasons. Now, maybe you don't think there's sufficient justification here. There, as far as I can tell, there really are no fact findings here. So maybe it's not warranted here, but there's not some abstract right. I mean, I don't think you can identify a case, can you, where the courts have recognized an abstract right to access information that says courts can't seal their records.
I'm sorry, Your Honor. I believe that the right to a public trial includes the right of public access to court records.
Does it include the right to release evidence that you obtain in discovery then, in your view?
No, I think discovery is treated differently. Discovery is regulated under court rules. I'm, as an attorney, prevented from disseminating discovery material. There's no need for a gag order in that respect. The court rules cover that. So I think the case law also suggests that discovery, the United States Supreme Court has addressed that discovery is a separate and protected class. I'm dealing only with the public record aspect, and I agree with you that absolutely the court can seal records after the appropriate analysis has been undertaken that shows a need to do so. In this instance, we have sealed every public record. In fact, I noticed that since we filed the final brief in this case, the circuit court clerk has added some notations to the electronic docket online. But while we were doing briefing, you couldn't even see the title of documents that were filed. There's no record of my client's entry of a not guilty plea.
Right. She sealed also Aaron Spencer's entire file. Not only did she seal Fosler charges, but Aaron Spencer's entire file was sealed until it was finally lifted just a little over a month ago, June 20th, 2025.
Did I
Was prevented.
read correctly at some point that the arraignment was actually sealed?
The arraignment, the court would not allow community members in the arraignment.
Right.
I raised an objection. It was not well taken. And so they were not allowed in the courtroom.
So no members of the public, no members of the press allowed at the arraignment.
I can't swear to that because my back was to them, but I watched the bailiff and heard him tell numerous members of the public that the court had ordered that only 2 members of the defendant's family and I believe 2 members of the victim's family would be permitted in. Whether or not he ultimately let somebody slide in, I cannot attest to that, but he turned away a line of people, and it wasn't 100 people, it was about 8 or 10, and he turned them all away.
So we haven't even, are you raising a right to public trial? Because we haven't, extended that beyond we haven't extended that to arraignment and further.
No, Your Honor, I'm not, but it is an important consideration here because Aaron Spencer may not have taken so much issue with this gag order if it didn't seem like this entire proceeding and the entire proceeding of Michael Fosler were being conducted in secret. And the public, members of Lonoke County, have a great interest in knowing how this happened and knowing why its public officials are making the decisions that they are.
Ms. Casanelli, you said something a minute ago that made me think that the remedy you're seeking here is for this court to remand or send this back to Lonoke County Circuit Court to have a hearing. Is that what you're asking for?
I'm asking this court to vacate the gag order and to provide the court and all courts in Arkansas with some kind of analysis, some kind of careful balancing, some direction, and order the circuit court and all circuit courts to conduct such analysis before they impose a gag order to ensure that it is appropriately narrowly tailored, only as is necessary to prevent substantial prejudice. That's what I'm asking for. And in this instance, the circuit court undertook no analysis, took no evidence. So there is nothing on which a tailored gag order could be created and imposed.
So the standard you just articulated, which case does that come from? I mean, I know that the cases say various things at various times. It's a little bit unclear what the U.S. Supreme Court has told us the standard is here. Where are you getting your standard from? What is the closest match? And is it the same standard applied to everybody that this gag order applies to, or is it just the standard that applies to you and your client?
So I would submit to you that the standard doesn't matter. Under any of the standards that have been laid forth by the Supreme Court, this gag order fails. I could talk all day long about whether Gentile sets a standard or Nebraska Press should be used, but I don't think my evaluation is that there is not a rigid test. I think the Supreme Court has said repeatedly, like the clear and present danger is not a formula. It is an indication of the careful balancing that should be done to ensure that a gag order is addressed only to a substantial and compelling public
But
interest.
the balancing language, where does that come from? I'm not familiar with a case that says balance.
Nearly every U.S. Supreme Court case talks about the weighing or the balancing.
But does
of-
it actually apply a balancing test as one would traditionally think of it? Or does it just say we balance in formulating the standard, we balance the interest? Or is it a pure balancing test?
It is not a pure balancing test. The court has been clear that it's unique to every case, but that it has to have the hallmarks of applying the heavy presumption of unconstitutionality as to a prior restraint, such as a gag order.
And in response to Justice Hudson's question, you were asked, you know, what are you seeking here? Are you just seeking sending it back for hearing? And you said you'd like guidance, but what I just heard from you is an amorphous test that doesn't really provide that. I mean,
Unfortunately, the United States Supreme Court hasn't addressed this situation because most often it's a defendant's assertion of a right to a fair trial that was not honored because of change of venue, or it's a press case. So I think we're looking to this court to help us in the state, to help us combine those cases and come up with what is the proper direction. But I do not mean to insinuate or indicate at all that there is a rigid balancing, because I think that the constitutional rights at issue don't allow for that. It's going
do I
to be
take from
different.
your answer then that you think the standard varies depending on whether the state has asked for it versus you've asked for it?
No, I do not think the standard varies. I think that the circumstances of the case are necessarily going to make, for instance, the state's compelling interest in a fair trial is going to have a different weight under the circumstances of each different case, as will the need to narrowly tailor the order. It necessarily has to be specific to the case, but we could use some real guidance as to what courts have to do to evaluate those issues.
Your time has expired. You can continue.
I see a lot of
Zero
mumbling in the
vote.
chat. Some people think it's a 3-judge panel. This is a 7-judge panel. This is the Arkansas Supreme Court. It's the highest court in Arkansas. They filed a writ of certiorari, which was actually granted. Remember, in the Karen Reed case, the U.S. Supreme Court did not even agree to hear her case. There are 7 judges in this panel. That way, there's never a tie.
Thank you.
Thank you.
Each attorney gets
The
20
attorney
minutes,
can
but she
respond.
reserved time for her rebuttal. Four women and 3 men.
Thank you. Madam Chief Justice, and may it please the court, I'm Assistant Attorney General Joseph Carl Lupke here today on behalf of the respondent, the state of Arkansas. The circuit court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. reviewing this order and Spencer's claims under the intermediate scrutiny standard set out the State Bar of Nevada.
Counselor, what would be the harm in sending this back to circuit court for an evidentiary hearing?
I think the harm is that there is sufficient evidence in the record to support the order here.
No,
It
there's
is
not.
undisputed. They didn't dispute it below. They haven't disputed it here, that there was sufficient media attention, expansive
always
media
media attention.
attention that supports the idea that there is a substantial likelihood of material prejudice based on statements from trial participants. And then the other thing you have is the statement that was attached to the state's order, which represented an effort on the part of the defendants and his attorneys to try this case in the press. And when you have a clear attempt to try the case in the court of public opinion rather than the courtroom, then it is appropriate to prevent.
Wasn't there just one statement here? I mean, you only attached, I think, one statement.
There's one statement by the attorneys. We read that, I think, yesterday or whenever we did the last stream. There is nothing more that I can do about the volume. You are in control of the volume on your end. I cannot boost it any further. I've turned my volume down all the way. You are in control of your own volume, earbuds. There's nothing more that I can do. I am not a cupcake. Can't make everyone happy. Sorry. We went over the statement that the attorneys gave the other day. It was very, we hear it in every single case. My client is innocent. He will prove it in a court of law. They gave some detail around what happened, and the public has a right to know that, and the defendant has a right to speak on his own behalf. And they didn't like it. Within 13 days, they were filing for a gag order, and within 9 minutes, it was issued.
Statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement that the defendant says was in response to something that the prosecutor had said cryptically. Like, that seems like a bit of a jump, doesn't it?
There is only the one statement in the record. That's correct, Justice Bronny. But I think when you read that statement, you can see
That's
the
Bronny.
intent behind it. And the fact that it was in response, or may have been in response to statements made from the state, those statements aren't in the record. The fact that the state may or may not have made statements only further supports the need for the gag order. The fact that both sides are talking means that a gag order is appropriate. And when you read the substance of the statement, it contains a style of argument that wouldn't be allowed in court. It has evidence as to the character of the accused and the character of the victim that may or may not be admissible. And so the circuit court needed to ensure that the case is decided based on the evidence that comes from the witness stand, and that's what the gag order does.
But you jump from one point to the other. I guess where I'm confused is I'm not aware of a case that says you have a right to the state or anybody else, a right to a trial without any publicity, which almost seems like what happened here. The circuit court decided there should not be any publicity. Instead, your right is to an impartial jury,
That's
right?
correct.
And why wouldn't things like voir dire be sufficient for dealing with that? I didn't see any findings to that effect here.
One, I think because voir dire was raised in the defendant's briefing below, it's implicit that it was rejected by the circuit court. I think you can find an implicit finding there. And I think what the Shepard versus Maxwell case says, and what Gentile itself says, is that when we're looking at ensuring a fair trial, the court has to act prospectively to prevent prejudice before it happens.
Counselor, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quick, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask you, how quickly do you read?
As
Whoa.
quickly as I can, Your
So
Honor.
if you had to guess, how many pages per minute do you think you read?
Go, go, go.
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection.
Yep.
And 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes,
Wow.
the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and made a decision and gave due weight to the defendant's objection in this case?
Yeah, try and answer that. Now it's down to 6 minutes. How fast do you read? You think she really gave the due consideration, or do you think it was already drafted? She hand wrote a couple of things in the 6 minutes and then quickly filed it. That's crazy. Crazy. She's covering her own ass. I could see it all the way from New York.
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing, but all we have in the limited record before this court is the file stamps. And the file stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know for sure whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court and it had the opportunity to consider it. So I think we can find an implicit
Counsel,
finding here.
let me ask you another question. When you're talking about discretion, and I think that's what Justice Womack's getting to, you said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020 in the Arkansas Democrat Gazette case when they brought a writ of cert to this court. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around
Right.
either by prosecutors or by judges at the circuit court level.
Right. The scratch and sniff order with no law in it whatsoever. A form that they just pass around, and then she wrote some notes and then was like, okay, put this in there, but don't stamp it until tomorrow.
And so that's my question is why would we treat it any different than the case we vacated in 2020?
I think you're dealing with who's making the petitioner here. The petition is the defendant and not the press, and we treat press cases differently than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored, I would compare
But
the
we
categories.
vacated it completely. We didn't just vacate it as to the press. We completely vacated it.
Abada.
And it had the same limits as to the defendant, the family, the friends, judicial officers. It was same language.
I can't,
He's
I'm not
sweating.
aware of that case, so I can't speak to that, and I apologize for that. But what I would ask this court to do is compare the restrictions here with the restrictions that were present in the rule in Gentile, and they are very similar. The rule in Gentile is found in the appendix to one of the opinions, and that was found to be narrowly tailored for First Amendment purposes. And so I think that this order
For
is.
purposes of the defendant's counsel, perhaps, but one, it wasn't a prior restraint, right, in Gentile, so that's different. And that was a case about defendant's counsel. Here, I think you concede, correct, that this order goes beyond defendant's counsel and applies to the defendant. Why doesn't that make a difference? Where do you get from Gentile that standard applies to others?
I think two things in response to that, Your Honor. In terms of why it would apply to the defendant and other parties, Gentile, while it did specifically address lawyers, some of its language said because lawyers have special access to information through discovery, client communications, extrajudicial statements, their statements are likely to be received as authoritative. All the parties here that are restrained are in the same boat. A statement from the defendant is likely to be received as authoritative because he knows what happened. And so the same justification that applies to lawyers would apply to him. I would also say that while Gentile dealt with a subsequent punishment, the bar rule at issue there was a prior restraint on the attorney's speech. It was a rule that existed that restrained the entire attorney's speech. He was then subsequently punished. But I think it can be viewed as a prior restraint
So
case.
that one, you could make the argument in Gentile that was people directly connected. There is language to that effect, but here we have an order that applies to any public official now holding office.
Yeah, and my first response to that, Your Honor, would be that those claims aren't in front of this court. The defendant doesn't have standing to raise them. And then secondly, while I say that public officials may be that may be broad and probably could be reformed. The idea that some public officials, like the sheriff who investigated the case, court clerk, other people who might have knowledge who were specifically directed, I think would fall into the same category as attorneys, defendants.
So answer the question that was raised earlier by one of the other justices. We're public officials. We all have clerks and administrative assistants. This morning, I sat in my office and discussed this case with 3 people that work for me. And we talked about the evidence and we talked about the issues involved. Did I violate Judge Elmore's gag order?
No.
Why not?
Is Judge Elmore going to be coming for me next, Assistant U.S. Attorney? Sounded like a challenge to me, and I love it.
It says any public official now holding office.
Because the restraints in the gag order are for public dissemination. Your discussions in your chamber are private. And in fact, they're, exempted from FOIA, that you have a right to in crafting opinions.
Facebook post by the Lieutenant Governor. Covered, not covered by this gag order.
Oh, yeah. Get him.
Arguably covered by this gag order, and I think the state would concede that that's probably inappropriate. She doesn't have any special knowledge.
You
of
say
this case.
inappropriate, do you mean unconstitutional?
I don't know that it's necessarily unconstitutional, but I don't think it was, I don't think that claim is before
He
this
knows he's
court.
got nothing.
So your boss is the Attorney General. Every legislative session, the Attorney General has a package of bills. Let's say he wants to go to the legislature and ask for a bill that addresses this very situation. He wants to add an affirmative defense to the statute in this type of scenario and has to give the reason why he wants to do that. So he lays out the facts of this case.
I mean, we're party litigants to this case. I'm responding. and
Okay, so
representing
let's say
this
it's the
court.
governor's package.
I think the
Did the
governor,
governor violate Judge Elmore's gag order in doing that?
I think the term public officials is probably, if the public officials claim were before this court, it's the general proposition of public officials is probably too broad and should be reformed.
So what about family?
I
Who's
think-
family? Is that spouse and kids? Is that the 4th cousin you met once at a family reunion 30 years ago that's talking about it at the coffee shop?
And I think that is part of the problem with the general term family, and it's the limits of the English language that perhaps that was not something the state requested. That's something the circuit court did on its own. I do think it is
I wish he would just go, you know what? I give up. You're right. It's unconstitutional. Vacate it. Just like hightail it on out of there. Because he's got nothing.
appropriate to restrain certain family members for the reasons I said. Spencer can't filter his speech through his wife or his mother or people that they would see as authoritative. But I think it
Are
would
you
be
reading that
appropriate.
in, then are you reading in the provision that talks about release, to Justice Womack's question, release any purported extrajudicial statement? Are you reading that as a limitation into the family language? Or I guess I'm a little confused as to the position.
I'm sorry, could you repeat that?
So the first here is basically you can't launder the statement provision. Any purported extrajudicial statement of the defendant. Are you reading that limitation into the family provision, or? is
I
it
think the
broader?
order says that the family is a restrained party and that is a restrained speech. So I think that would apply. I think that's a fair reading of the
So
order.
counsel, if defendant planned to call his daughter to testify, he couldn't publicly announce that, correct?
No, under the terms of the gag order, the identity of witnesses are protected. I
But-
think
Then why is that necessary if you can publicly say the arresting, investigating officers and agencies are public and they're going to be necessarily witnesses? So why can the defendant not release his witnesses, but obviously the state can publicly name some of their witnesses?
I think that, first, I think that the defendant's daughter could be a witness either for the state or for the defendant, same as the investigating officers
he's-
could be witnesses for
give me a
either.
break.
And I just think that the terms of the order says that you're allowed to identify the arresting officers, but you're not allowed to release witness lists, and that's to try to ensure a fair trial by preventing witness.
A fair
Fair trial for who? Oh, she's going to say that, I think. I haven't watched the whole thing. Let's just pause right here to give everyone a chance to smash the like button because more people need to know about the Aaron Spencer case. And there's about 6,000 people watching and only 1,700 likes. And we can do better. I know we can do better. Sometimes you forget, but it's kind of like wiping your feet on the mat when you walk into the house. Just smash the like button. I promise you, Canton PD will not get a hold of your DNA.
Trial for who?
A fair trial for the public and a fair trial
For the public?
Mr. Spencer. It's a fair trial for all parties involved and for the people of this state.
Can I ask about the overbreath thing? Because I'm not sure that I got a clear answer from opposing counsel about whether they're raising an overbreath challenge, but it's certainly in their brief. What is your view of how we would conduct that inquiry? Because normally you have a statute, it's very clear, there's one standard that would apply across the board. It might be unconstitutional, or it might be constitutional as to a particular person before the court, unconstitutional as to others. Here, assume for a second with me that the court has set different standards for different people, or certainly different articulations of the standard for different people. So what do I do on the front end to determine whether or not there's substantial overbreath? Do I have to go through every group in the order and apply a different standard and say, well, it's okay here, it's not okay there? So I add them all up and somehow it's substantially overbroad? Or how do I do that in the state's view?
I'm not sure I can answer that question. And I think your question demonstrates why an overbreath challenge isn't appropriate here and wasn't raised here. They're raising separate challenges as it is to his speech, as it is to the other speech. They're raising a bunch of different as-applied challenges. They don't have standing to assert it on behalf of those other parties, and that's the problem. And I think that there is a possibility that different standards could apply to different parties, which wouldn't lend itself to an overbreath challenge.
And then
the general public, sorry.
On that standard, then, I guess, what is your view of what Gentile says and what Nebraska Press says, and what is the difference between those two standards?
Nebraska Press is they're dealing, well,
They deal with different people, I'll give you that, but other than that, what is the difference in the articulation of the standard?
I think not only do they deal with different people, they deal with different First Amendment rights. One is dealing with free press and one is dealing with free speech. And those are different delineated rights in the Constitution. I think that open press, they talk about there being open discussion in this case in the public. We view that with much greater scrutiny in the law. Whereas the trial participants, what Gentile has said, what Shepard has said, and what Nebraska Press has said are viewed under a much lesser standard because it gives the court room to balance fair trial versus those First Amendment
So
rights.
why does the different standard matter here? Because as I understood your articulation of the interest here, I think your view would be that you survive strict scrutiny. So like, what is the relevant difference in the standards here? Because you started by saying this is intermediate scrutiny. So you obviously care about the standard. I guess I'm trying to figure out why does that matter here then?
Well, it matters here because not only are we trying to ensure a just result in this case, but we're setting the standard going forward. And for future cases, that's what this court does. And I think it matters specifically where intermediate scrutiny versus strict scrutiny matters in this case is when it comes to what narrowly tailored means, and specifically the consideration of least restrictive means. Under intermediate scrutiny, this court does not have to, or the circuit court did not have to choose the least restrictive means of choosing its goal.
That's generally true, but doesn't some of the language in Gentile indicate that maybe this is like intermediate scrutiny with a bite almost?
No, I didn't read it that way at all, Your Honor. I think the language specifically said that the court doesn't have to rely on things like voir dire and a change of venue because those will come after the damage is done. We don't know and cannot know that as Nebraska Press, the known and unknowable, whether or not they will be sufficient to do the job. And given the primary constitutional duty of the court is to ensure a fair trial, it's important that they act
So
prospectively.
your primary interest then is in avoiding tainting the jury pool? That's the state's interest here, or is there another interest?
Yeah, well, I think it's in ensuring a fair trial, which involves tainting the jury pool and protecting the witnesses from harassment. I think there's twofold. I think if you read the restriction in
Protecting
the
the
order
witnesses
about
from
the
harassment?
identity of witnesses, that would go towards protecting witnesses.
So what about then the restrictions on making statements about a witness's testimony after the witness has already testified?
Yeah, that's
What
insane.
purpose does that possibly serve with respect to either the jury pool or intimidating witnesses?
I think it depends upon whether those statements are made in a pretrial hearing or in a trial. I could see and concede that when the jury has already been seated, that there wouldn't be reasons to restrict statements anymore to the press as long as the jury is sufficiently sequestered or sufficiently instructed not to
Counsel,
read precedent.
The jury is sufficient. Do they sequester juries in Arkansas? It is a very rare thing nowadays. There are hardly any juries are sequestered anymore, sir. Good morning, Kelly Reed. Kelly Reed is here. Good morning, Kelly. I thought Massachusetts was where your constitutional rights go to die. And knowing what I know about what this court is going to decide, I am going to say that Massachusetts may still be the place your constitutional rights go to die, because Arkansas may have one up on Massachusetts for now.
it feels as if the discussions that you're having with my colleague are having well-reasoned discussions about where this perhaps could have been limited more, tailored more, and that would have been the benefit of having a hearing in front of the trial court, where the trial court could have had these discussions about what really the harms were out there, what you were trying to prevent, and that would have happened rather than sort of whether it happened in a day or 6 minutes, a quick form response.
I think the circuit court had all the information it needed in front of it to craft the order that
6
it did.
minutes.
And I think that that order is narrowly tailored. It specifically targets public dissemination of the evidence in this case, and just that. And that's to prevent
And the
ensure-
fatal flaw with that is that we vacated a virtually identical order in 2020.
I think that Gentile would say that
Well, it
this,
doesn't really matter, does it? That's US, we're saying an Arkansas case.
I think when we're applying the First Amendment, what the United States Supreme Court says matters.
Well, I would disagree when they've raised an Arkansas constitutional right here.
And I don't know that
We
this,
can give more protections, correct?
we can give more protections. They did not develop an Arkansas constitutional argument. I don't think, while they did cite it, they did not develop it. They
It's hard to
purely
do
relied.
without a hearing, isn't it?
I
develop
think they
that
could have
argument.
developed it in their briefing. They had a
Oh,
full
yes, it
briefing
is.
schedule. This court requested additional briefing. I
But would it
just-
matter if that prior order from this court was a syllabus entry instead of a reasoned opinion? Does that make a
I think
difference?
it does make a difference, because I think the important thing today, and what I would say in closing, is we want to adopt a good standard moving forward. It's important to ensure that justice isn't done in this case, but this court's opinions matter going forward. And so I would ask this court to adopt the Gentile standard, because it gives the court room.
Counselor, I know you said you were closing, but I have a question for you. On the last page of the order, right above the judge's signature, it says the entire case is now sealed. What does that mean?
It means that the public docket and the docket entries are no longer public. That's what I
Wow.
took it to mean.
That's what you took it to mean? Do we know what that means? Does that mean that we're not going to let the public into the various hearings and portions of the trial that happen going forward? What, do we have any extrapolation somewhere else in another document from the judge to kind of expound on, what she meant when she said the case is now sealed, the entire case is now sealed?
No, the only thing I'm aware of is the order before this court. And I think when we talk about sealing, I took that to mean sealing of the record. The defendant has a right to a fair public trial, and I have no reason to believe that that's not going to happen.
Really? You gonna
I'm
let
out
the
of
cameras
time. I
in?
would ask this court to deny the petition for writ of certiorari. Thank you.
He's like, I gotta get out of here quick. Please let me go. I'm sweating to the bejesus. I got the sweat going on, dripping down my brow. Anybody have a rag or a hanky?
Counselor, as it applies to
Rebuttal.
the other party, the non-parties and the non-participants. So essentially the family members and let me make sure I get the precise language, any public official now holding office, as it applies to them. By having a gag order on them, is there any prejudicial impact on your client's rights to a fair trial or your client's constitutional rights otherwise? And if so, what is that prejudicial impact?
I would say there is a prejudicial impact. Each case that I believe in state court and in federal court that's evaluated gag orders in a similar way has addressed the scope of coverage as to third parties or groups of covered third parties. I should have made that more clear earlier, whether or not it was specific as to a very precise prejudicial effect on the defendant. However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lonoke County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both as a citizen and as a criminal defendant. And I think every case that's analyzed this has, without real discussion, evaluated the scope as it applies to other people, as well as the scope of its application to different types of speech and other matters. So I think that that's a proper consideration. And it also, as I said before, contributes to the court's finding that the order is not narrowly tailored.
The cases that you're referring to that do that, they generally do that either because it's a press case or because it's an overbreath. So take Murphy Brown, for instance. Judge Wilkinson's opinion basically just says, we're applying overbreath analysis, never does sort of a preliminary determination of how that would work. So the same question that I asked the state, how do I conduct that analysis? Do I have to do some like different test application? Assume with me for a second that I disagreed that strict scrutiny automatically applies to all of it. If I have to do that, how do I do that analysis, sort of the preliminary front-end analysis? Or wouldn't it have been easier to frame it as a facial challenge?
I think you can tell that I think that's a tough question. I think that there are different standards that apply, and unfortunately here none was applied. So any standard would be better than no standard, but I think the court does have to consider what burden must be met to prevent non-parties from speaking. I don't disagree with the state that trial participants can be restrained in ways that are more substantial than third parties, people who are not within the proceeding. I can't legitimately dispute that. But the cases, Nebraska Press, Shepard, they don't articulate for lower courts how to do that. No Supreme Court case does, which is why we're having this discussion and why there's not a defined answer to it. But I think the circuit court has a duty to take care to address those categories of persons in specific ways, because those rights are different and they are to be evaluated differently. I want to be sure to state to the court, there is no case that applies intermediate scrutiny to gag orders to this circumstance. There just isn't. There's no case that dispenses with the least restrictive means analysis. Gentile does not do that. In that case, it was a subsequent punishment at issue, not a prior restraint. That cannot be reasonably disputed. The Supreme Court has told us that those things are viewed differently and prior restraints are
It says that, but when have they ever actually indicated how the standard is different? I mean, I recognize you're entirely right. The court has said prior restraints are treated differently. Tradition in this country, we treat them differently. But when it comes to actually analyzing them, can you point to the delta in the way that the court has treated them differently?
Yes, I think the court historically has consistently held that prior restraints are what they call freezing speech as opposed to chilling it. Because when you speak in the face of a rule that tells you of an ethical rule, you are aware of the danger in doing so. It's very different.
I agree with you in those general terms, the court has said that, but where has it applied a different standard?
I don't know that that's specifically come before any court. I mean, I cannot think of a case where that has been specifically addressed. In my mind, that is something that is stated repeatedly. The evaluations of rules like the ethical rule in Gentile have been evaluated slightly differently. I would say this as it pertains to Gentile in this analysis, that because it was a regulatory rule, the court was looking at the systemic issues So the court was looking, they didn't dispense with the least restrictive means. They didn't have a case to apply that analysis to. So they're, in that instance, they're looking at a rule. Is this necessary in a profession that we as a state license? Can we impose this ethical responsibility? And how does that rule affect sort of the systemic costs that may be associated with it? In a case in a trial court, I mean, we don't hear circuit courts say, well, you know what, we're not going to do extensive voir dire because it's too expensive. You know, we're not going to change venue even though maybe a defendant's entitled to it because it would just be too much of a cost on the system. I mean, that's, Gentile is obviously dealing with the overall systemic assessment, but within the First Amendment analysis.
Well, counsel, I think what the state was saying is that they thought that perhaps some of what you said in a statement, you could not have said in court. Would you agree with that?
I'm sorry, I could not have said.
You could not have said in the court.
Mhm.
You could have not made some of those statements.
Well, I have sort of agree and disagree.
Okay. Well, and so I guess following that is that once you did that, was there a legitimate concern by the court that maybe you were going to keep going further, and then that justified the court issuing some sort of gag order, if maybe not this far, against at least counsel?
I think the court, and I think the Trump court talks about this in that opinion, that context is important, and that has been completely ignored by the state in its briefing before this court. That statement was made before arraignment, before there was any proceeding. It is a criticism of a public official. It doesn't include any information that is prejudicial or would be inadmissible. The character of my client will be at issue because he is of outstanding character, and there's nothing that's going to impact
preach.
that. Michael Fosler's rapes of Mr. Spencer's child are public record. It is a part of this case.
Right.
And that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point. The very person who was responsible for Michael Fosler's case. So
Was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also when a prosecutor made a comment on camera, what's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding. So if you don't take them in context, you may think that I'm talking about the jury as the community, but I'm actually in full context was talking about the community's involvement and support of him in that proceeding and being told to go home. So I think if the court had taken evidence, then we could have fleshed all of this out. My practice is not to try my cases in the press, and I would have probably agreed to some restrictions as necessary, depending on what they were. But the court didn't evaluate any of those things. And of course, the court didn't find out what I was speaking in response to. But I submit to you that there's really nothing in that written statement that should be even prejudicial. Even under the current gag order, his occupation, his family history, all of that is apparently okay to speak about. Public records are okay to speak about, and those are based on public records. So, I mean, just because the prosecutor doesn't like it, that is not a reason, that's not a justification for a gag order.
So if we construed this order narrowly, I realize that it might be somewhat difficult to do, and just treated it as a poorly written order and construed it as most of the provisions have to do. I mean, there's the one about extrajudicial statements of the defendant, but otherwise, for the most part, what we're talking about are public dissemination or public comments about evidence, prospective witnesses, testimony, etc. If that was construed narrowly to be limited to statements about that are aimed at basically tainting the jury pool, releasing evidence, commenting on evidence, that kind of thing, does that give you the relief you actually are seeking, or is that not enough? And would that pass? I mean, the other question is, would that pass as relevant test?
It's difficult to answer that in the abstract. This order says things like possible existence of evidence. Like, I don't know what the possible existence of evidence is.
None of
You
us
know, if
do.
we could define those contours better, then perhaps so. But, you know, some things that are potential evidence or possible evidence should be fair game for the public to learn about too. So I think we should be narrowing this to prejudicial evidence, not anything that possibly could ever be evidence. And not all of this order addresses even public dissemination. And I'm sort of unclear even what that term encompasses. You know, social media is a big thing. There was lots of comments on social media. If family members have private social media accounts, is that public dissemination?
Does it matter that the state conceded that a Facebook post would be covered by this order?
The state in its briefing suggested so. I'm not sure I agree with that. I think that may not be public dissemination. I've been asked these questions and I can't give the answer any more clearly than anybody else from reading that order. I want to point out to the court that we do dispute the extent of the media coverage, the undisputed nature. Everything is in dispute here.
Mhm.
Yes,
We
there was
dispute all of
media
it.
coverage. I don't think it was near as extensive as I've seen in many other cases, but we don't know because the court didn't take any evidence. So there's no basis for that statement. There's no basis for the statement that our written statement was the cause for the gag order. Nobody even alleged that in the motion. Nobody found that in the order. So I don't think that that's a fact that the court can rely on. I also want to suggest to the court as to the standard, and by the way, there's no evidence of risk to witnesses. No one has even raised that. That was commented on a moment ago. I don't know where that came from. There's been no allegation of that, no indication of that. But as to the standard, I do not deny that Gentile may provide some general baseline test for trial participants, but it cannot be the only expression of a test because of the limitations that we've discussed previously as to the regulatory nature and the lack of prior restraint. I think the court has to consider the heavy weight of the First Amendment rights that are at issue and honor those. And here, Aaron Spencer's not asking for a gag order. It's his Sixth Amendment right to a fair trial. And that is usually raised by the defendant in cases where the defendant attacks a gag order. We are not doing that here. So there's not a Sixth Amendment right as competing with a First Amendment right, as is discussed. I think Nebraska Press talks about how the founders didn't tell us which one should win the day. But that's not the issue here. The public has a right to a fair trial, sure, but they also have a right to hear my client's speech and to know what's going on in their judicial system. Thank you.
Preach, girl, preach. Preach. That is it. That is the argument. Okay, I'm going to give you a second so that I can adjust my volume back to normal, and you can adjust yours. Okay, ready? 1, 2, 3. Okay, this will be my new volume for you. There were no closed captions on that feed. Sorry about that. That is the Arkansas Supreme Court. I guess they do not believe in closed captioning. I find that to be very interesting. I hope that you found it to be as interesting as I found it to be. I think it's fascinating to watch Supreme Court arguments. I think it is fascinating to see an attorney who can try a criminal case also get up and argue in front of the Supreme Court. So that was argued on April 10th, 2025. They rendered their decision May 29th of 2025. The circuit court did not overturn the gag order, vacate the gag order until June 20th. I have linked the full opinion below for you. It is 29 pages. I suggest if you're interested in it, you should read it. But what I want to read to you is the concurring opinion by Judge Bronny. I've read it before, but it's worth repeating. There are a lot of you here that do not know anything about this case, and I would like you to hear Judge Bronny's opinion. He was the judge. I think he had really the most questions. he was the one in the 2-shot sitting next to a female judge, darker hair, and he had a lot of questions. And he wrote a concurring opinion, which means he agreed with the majority opinion, but he had some more things to say. So he added his own, maybe it's 3 pages. And this is pretty scathing. So I want to read it to you. Here we go. This is the concurring opinion by Nicholas J. Bronny. Let me take down this banner. And here is what he says, concurring. Public officials aren't immune from public criticism, judges and prosecutors included, because the circus court, that was Freudian because it is a circus court, because the circuit court's gag order violates that principle. I join the majority's opinion granting the writ and vacating that order. So the gag order was vacated by the Arkansas Supreme Court. And he's going to give us some of the reasons here. But that sweeping order is only one part of a troubling pattern of attempts to shield this case from public view, beginning with a non-public arraignment and ending with a handwritten note sealing the entire case from public view. We cannot allow that pattern to continue unchecked. So I'd invoke this court's superintending authority and reassign this matter to a new circuit. No, I just want to say circus. A new circuit court judge. He would take this and he would assign it to a different circuit court judge. Anything less suggests that what's happened so far is within the acceptable range of disagreement or administration, and it isn't. Begin with the gag order itself. On its face, that order targets a broad swath of people, barring them from, quote, expressing an opinion, making any comment about whether the evidence tends to establish the guilt or innocence of the defendant. Worse, the order itself was sealed, raising serious concerns about selective enforcement. And it doesn't explain why such an extreme remedy was warranted, instead just declaring it would help ensure all parties get a fair trial. Nor did the circuit now I can't stop. Nor did the circuit court explain why it extended the gag order beyond what even the state thought was appropriate, broadening it to cover the defendant's family, and even more significantly, sealing, quote, the entire case, end quote. On the contrary, the circuit court entered that order just 6 minutes after the clerk docketed the defendant's 19-page opposition to the state's motion, or barely enough time to make a pot of coffee. I love that line. Barely enough time to make a pot of coffee. That approach cannot be squared with the First Amendment, and it underscores that the gag order wasn't a last resort, but an unconstitutional impulse. Wow. Think Judge Elmore has impulse problems? Or she's trying to cover her own ass? Back to the document. Context suggests why. The same circuit court that issued the gag order here also granted Michael Fosler's release on bail. It is that decision, which the defendant's lawyers called a decision to release a predator who repeatedly violated the defendant's child on a low bond, that set off a chain of events that led to the fatal confrontation that is the subject of this case. And it's that criticism that the state claimed and the circuit court effectively concluded justified gagging the defendant, his lawyers, and others. This sequence raises serious concerns. Indeed, if openness enhances the appearance of fairness, so essential to public confidence in the system, then secrecy has the opposite effect. It erodes trust. The effort to shield these proceedings from public view also didn't begin with the gag order. It started with the circuit court's decision to arraign the defendant away from public view. And even setting aside the potential constitutional concerns raised by a non-public arraignment, that decision highlights the order on review here isn't an isolated problem. Rather, it suggests a star chamber-like atmosphere. We cannot allow that to continue. Okay. Indulge me for a second. What is a star chamber like atmosphere? Is that like a Star Wars reference? I don't know what that means, but maybe you guys do. Star chamber, like capital S, capital C. Dina says, wow, he's taking me to church. It's a reference to something in pop culture, I think. A star chamber like atmosphere. Is it Star Trek? Is it Star Wars? I don't know. Maybe I'm just old. But I feel like he and I may be in the same age bracket. So if anybody knows, then let me know. Nobody has any idea. Star chamber. All right. You guys can, I don't know. Ultimately, judges and prosecutors enjoy no greater immunity from criticism than other persons or institutions. It's a film from 1983. Oh, Star Chamber was a movie from 1983. In secrecy? No, it references a film where dirty deeds are done behind closed doors. Star Chamber is a movie. Okay, good. Good, guys. See, we're so collaborative here. So collaborative. Oh, movie about judges and lawyers that were meeting in secret to put away people, starring Michael Douglas. Thank you, Michael L. Love Michael Douglas. Okay. Maybe I'll have to put that on my list. Remember when we used to order Netflix CDs in the mail, DVDs, and Netflix would come in the mail in the red and white envelope and be like, oh, Netflix is here. And then you had a queue. And then your next one, after you mailed that one back, then your next Netflix DVD or whatever the hell it was came to you in the mail. That's crazy. But we used to have to do that. Oh my God, we're so old. Ultimately, judges and prosecutors enjoy no greater immunity from criticism than other persons or institutions, nor should they. Public vigilance serves us well, for the knowledge that every criminal trial is subject to contemporaneous review in the forum of public opinion is an effective restraint on possible abuse of judicial power. Instead, justice should not only be done, but should be manifestly and undoubtedly be seen to be done. So I join the majority's decision granting the writ and vacating the gag order, but I would go a step further. The repeated attempts to veil these proceedings in secrecy can only breed ignorance and distrust of the courts and suspicion concerning the competence and impartiality of the entire criminal justice system. Remedying that danger warrants strong medicine, and I'd apply it. There you go. He would take the judge off the case. However, the majority opinion sent it back and said, you're free to issue a less restrictive gag order. And in fact, in a recent article that I read, can't put my fingers on it right now, but the DA said, oh yeah, we don't know if there's going to be another gag order. We may have a hearing on that. So they may want another gag order that's not as restrictive. And good, Justice Nicholas Bronny might be my new favorite judge. Tracy wants to know, how did the guy initially get in contact with the victim? We're not really quite sure. The mom has posted some stuff on the Facebook page, which is a link below this video, that it may have been something online. There may have been some online grooming going on. She also said that her daughter had been homeschooled and she was a very quiet child and a very reserved child, and that she had been taking care of her grandfather, who was very, very ill, and that the mom wanted to give her a little more freedom because she'd been, working so hard, taking care of the grandfather. He is charged with internet stalking, right? I'm not sure if that's how initially he got in touch with her. He was also unknown to the parents. There may have been another girl involved. I'm not sure if she was also targeted or abused, but there was some talk about, on the night of her disappearance, a DoorDash receipt between the guy and the girls. So I'm not really quite sure, but I think that's how. And listen, the girl was real brave to disclose, because those of you who know, disclosure is rare. Disclosure at the age of 13 is very rare. And, praise be that she had people that she could trust to talk to about this, or this guy might still be running around out there. And statistics show that a predator like that will violate 100 times before they're caught. So I'm pretty sure there's other victims out there, and hopefully maybe they'll come forward. And who knows what happened in Indiana when he was the chief of police there. But I'm going to thank you, Mrs. Bouquet, for your super sticker. I will tell you about some of the other horrors that I have found out about in the Lonoke County Detention Center involving a federal lawsuit against the sheriff, John Staley. If you guys live there, you might know about it. It was filed in 2023. It's 60 something pages long. I'm reading it right now, and I'm hard to offend. You know, you can say a lot of things. It's not going to offend me. I'm not easily shocked. I've seen pretty much everything. What I am reading in this federal lawsuit by a woman who was going by the name Jane Doe about what happened to her while she was being held in the Lonoke County Detention Center has me shooketh. Shooketh. It's horrific. We're going to have to do that on another show. But I hope you're interested in it, because I sure as hell am, because this has been going on in Lonoke County for a long time. And it's the same kind of thing, maybe, that we were seeing in Norfolk County, where everyone's, you know, protecting everybody else and people are looking out for their own. And, you know, seems very clear that Judge Elmore issued this gag order to protect herself, because she didn't want the public knowing that she's the reason Fosler was out and was able to reoffend against the Spencer's daughter, and did reoffend several times, apparently, according to some articles that we read yesterday. And I am shooketh and outraged. And you know what happens when people tell me not to talk about something? I get louder. I get louder. You can shadow ban my videos on YouTube. You can you know, try and get me demonetized for not talking about subjects that are unfriendly to advertisers, because they don't want to talk about the sick, disgusting predators that are out there. But I'm still going to talk about it, and I'm going to talk about it louder. Yeah, there may be other victims in Indiana, and that's why I moved to Arkansas. Right. Jojo says the real questions are, court, is this the hill you want to die on? You're willing to protect these kind of monsters? Nope, they didn't. As you can see. Thank you very much for your super chat. Lisa said, Melanie, are the appeal judges usually this antagonistic? I did not, and I saw you put this up and I started when Erin Casanelli was speaking, and I did not find them to be antagonistic at all. But the appellate judges are there to question the attorneys. And they want to know the attorneys are on their toes and they've got questions. They've got to render these long decisions, and there's 7 of them. And you need to be prepared when you get up there to argue in front of an appellate court. You need to be prepared to answer those questions. And so I did not find them to be negatively antagonistic, but yes, they will challenge you, and you better be ready, and you better know your case law. And I think she was far better prepared than the assistant. Was he the assistant attorney general, I think, for Arkansas? Becky says, Melanie, you read yesterday that Fosler was hit multiple times and that AS emptied his magazine. What document was that? That was in the Arkansas, I think it was an article in the Arkansas Times. Let me see if I can find it, and I'll link that below for you also. Hang on. Yeah, this is from the Arkansas Times. And somehow this reporter got a hold of the affidavit for the arrest. Let me put it up for you, and I'll link it also in the show notes below. Hang on. This is Arkansas Times, and it is an article by Matt Campbell, June 24th of 2025. And he's got a lot of details from the arrest affidavit, which we are not able to access. So good on this reporter, Matt Campbell, who somebody said, I think, in yesterday's show, that he's also an attorney. Let me put in here, Arkansas. All right, it's now in the show notes below. I really, really hope that, oh, and see, it's got the M word in there. That's probably why I didn't put it up yesterday. Oh, well, YouTube doesn't like that M word. I hope that some news organizations make a motion to the court to open this up to live streaming, or at least Zoom. Do they even have Zoom capabilities? Because when I went on the website for the Circuit Court of Lonoke County, which is a non-secure website, by the way, here it is. I'll show it to you. Here it is. This is the state of Arkansas, 23rd Judicial Circuit in Lonoke County, 1st Division. And this is the only judge in the building, Judge Barbara Elmore, who has served as circuit judge since July 2007. Judges, I'm told, are elected in Arkansas. There she is, Judge Elmore, and then her court reporter, and then her clerk. and not a whole lot of information. Like when you go to the FAQ, there's no Zoom information. I don't know if they do Zoom there. So there's not a whole lot of information here. And I am told they normally, I mean, I would imagine that it's judicial discretion whether there can be cameras, but do you think, thank you, Becky, for asking, do you think they're going to Zoom this or televise it? I hope that some local Arkansas stations or even Law and Crime or Court TV get on the ball, get in there, make your motion, get a pool camera in there because we want to see it. Sequoia says she's been running unopposed in her last election. Smurfana says, my state does not stream trials or hearings, etc. Oh, you mean on Zoom or anywhere? Happy anniversary, Melanie. Happy Melanie-versary, Jadzia, who has been with me for 12 months. It's been, what a great year we've had, right? Michelle says, I feel like I'm watching the old Comedy Central show, Roast. The Arkansas Supreme Court is roasting Elmore. Isn't that great? I loved it. I hope you guys liked it too. Who's got a motion hearing today? KP? You mean Mafia Masshole has a motion hearing today? When? Oh, the Supreme Court already ruled, Dr. Trey. I covered it on my first stream on this show. The playlist is below, and also the entire decision is below, and they overturned the gag order. Yeah, I was going to go there for the trial too. Is Bob going to go there too? If I can get away, I definitely will. It's only supposed to be a 5-day trial, but we need to see if it's going to be adjourned or anything. So who's got a motion hearing today? Jocelyn? You can't record in the courtroom if you go in there, and usually you cannot. I can't direct every single person on where to find every single thing, but you guys can help each other because that's what you do. Grace, shouldn't you be studying? Grace is taking the bar exam, everyone, very soon. Shouldn't you be studying, Grace? Everyone wish Grace good luck on the bar exam. I mean, not the bar exam, the LSATs. I'm sorry. LSATs. Grace is taking the LSATs. She says, the amount of case law I'm passively absorbing through your commentary, reading motions, and listening to these hearings is invaluable. Oh, thanks, Grace. Not the bar. The LSAT. She's taking the LSAT. I'm sorry. Tony says, Melanie, I just started watching your coverage of the Karen retrial 1 and love when you discovered Ali Mata. You are queens. I love Ali Mata too. She's my sister from another mister. She's my my own personal Catherine Zeta-Jones. Doesn't she remind you of Catherine Zeta-Jones? Love her. Dr. Brian Luke became a new member. Welcome. M169 says, all these current cases exposing so much corruption, I urge everyone to familiarize yourselves with the story of the Battle of Athens, Tennessee from 1946. All should know, especially corrupt officials, as a warning. Thanks for your 20, girl. Scott Robinson wants to know if his trial will be streamed. We so far, no. So far, no. Yeah, the bar exam was yesterday and today. Oh, I hope your daughter is doing well, Jean. I remember it was a 2-day, when I took it in New York, it was a 2-day exam in the Javits Center. Are they still doing it at the Javits Center? It was 100 years ago when I took it, Jean Phipps. So far, no streaming. I mean, the judge didn't even want anybody talking about this case. But hopefully somebody will get in there and make a motion. Smurfana says, Star Chamber refers to a former English court, arbitrary and unfair proceedings. Original Star Chamber, officially the Court of the King's Council in Star Chamber, was established in the 15th century. Thank you. Thank you, Smurfana, for your super chat and for teaching us a little something today. eBay Warhol is here. It is a court that operated in 15th to 17th century in England. It is now a derogatory term to describe unfair and secret legal proceedings, Star Chamber. Thank you. I think, Jessica, I think this is the year of uncovering corruption. Thank you, Tracy. I think it is. And it's also the year of like the Innocence Project of YouTube, which is what I'm going to start. Listen, we saw Brian Camp acquitted. That was amazing. Brian Camp brought us to Tom Kokanowski, who I spoke with yesterday, by the way, on the new Karen Reed motions. Let me just finish with the super chats, and then because I always forget where I'm going, and then I digress. So let me just finish this thought, and then we'll talk about the Karen Reed motions. Mathis says in late medieval to early modern England, there was a type of court used against people so publicly well connected, the court would fear retribution. Thank you. Everyone's got the Star Chamber, but apparently it was also a movie, right? Mathis also says, think grand jury setting. It's named after a nobles only room with star ceiling. Since there's no noble class anymore, the association is plebes out. Thank you. I don't need a badge says, can the defense motion SC that charges be dismissed? And if there is only one judge in the county, can it be moved to a different venue? Thanks for showing what goes on at Supreme Court hearings. I learn more every day. Oh, thank you. I liked it too. I like it. I found it really interesting. Supreme Court. Okay. No, they can't ask the Supreme Court to dismiss the charges. That would be, they can make a motion to dismiss in the circuit court, which is where they're in front of Judge Elmore. Can it be moved to a different venue? They would have to make a motion. The defense would have to make a motion. And that may be forthcoming, but there is the pretrial hearing, which is supposed to happen August 8th, which is next week already, right? And then they could make a motion to dismiss, but we're getting close to trial here. We're getting close to trial. I don't know what the deadlines were because a lot of the documents are not accessible. So usually there's a scheduling order that says all motions have to be made by a certain date. I don't see that in the docket. And so thank you for your question and for your super chat. Ocean Beach, 1, fascinating Supreme Court justice publicly introduced idea of jury nullification. 2, has defense done a formal request for judge to recuse? Not that I can see in the docket. Supreme Court just called her out. Yes. 3, there are workarounds for YouTube monetization. Yes. Thank you. Thank you very much for your super chat. I still don't know what the KP hearing is today. And yes, Jesse Schul is here. He's got a channel too. Talks about football. Long live Coach Prime. Coach Prime, Deion Sanders is the coach for my alum, University of Colorado Buffaloes, Go Buffs. And it was just announced that he had bladder cancer, he had surgery, and now he's cancer-free, and he's going to be coaching this year. Originally, the headline that I saw, I was like, oh no. But yeah, long live Coach Prime. So, Go Buffs. Go Buffs. Okay. So, Karen Reed has filed apparently 2 motions. I only saw one. But there's 2. So she filed 1 motion to get back her Lexus and her cell phone that was initially seized in the murder trial by Yuri Buchanan and Michael Proctor from Dighton all the way back on January 29th of 2022. They still have her vehicle and they still have her cell phone. And then, I don't know when it was, but another time they went to her house and seized 2 more of her cell phones because they were trying to indict Karen Reed and Aiden Carney, aka Turtle Boy, on conspiracy to commit witness intimidation charges. They went to a grand jury on that and no true bill was returned, meaning that even though Saul Wackler, who is the Chief Justice of the highest court here in New York, we call it the Court of Appeals, other states call it the Supreme Court, Saul Wackler infamously said, a good prosecutor can get a grand jury to indict a ham sandwich. And the grand jury in Norfolk County did not indict the ham sandwich. That was Karen Reed and Aiden Carney, but they still have her cell phones and she's never received her property back. So I reached out yesterday to Tom Kokanowski, and he's a Massachusetts attorney, great defense attorney. If you need him, check out his website. He works all over the state of Massachusetts, everywhere. I think the Cape, he's got an office in the Cape. He's got an office, where's the other one? Springfield or something. He defended Brian Kemp. We saw Brian Kemp acquitted. I said, what is up with this? Why is Lally ignoring the attorney's calls to return the property? What's going on here? He said, in over 30 years of practice, I've never had to make a motion to get my client's property back. I said, what happens after the acquittal? Do they return the property? He said, yeah, usually you call, like the attorney, they call the officer in charge of the evidence room or whatever, and they just give it back to you. You should not have to make a motion. And it's crazy, right? She could probably auction that car off for a lot of money. Like maybe some museum would want it or something. I don't know. Apparently they're trying to auction off OJ's Bronco. And it's like it's valued at maybe $1.5 million. I don't know. But I don't think that first of all, the 2 cell phones that were seized in the non-true bill case where they never indicted her, should just get back to her. There's no excuse for even still having them. And I don't think that the actual cell phone of Karen Reed was ever marked as an exhibit and entered into evidence. There's no reason, there's no strings attached to that. Brian Walsh, who was alleged to have, cut up his wife and put her in dumpsters all over town. It's a nobody case. In the same county, got his devices back in 16 hours. So why can't she get her phone back? Was her car actually entered into evidence as an exhibit? I don't really think so. I mean, I know that the jury looked at it. I know the data from her car was entered into evidence, maybe, or they spoke about it. The experts did. But here's my thoughts on this. Why would Lally be ghosting Karen's new attorney? I'm just, brainstorming with you, just brainstorming. If any of those items were tampered with while in the custody of Massachusetts State Police and or the DA's office, because, they are one and the same, giving that property back to Karen could be further fuel for her Section 1983 cases against the county and the MSP. Because experts could take a look and probably tell whether or not that stuff was tampered with. Because remember, we learned at one point that Karen's location data of her cell phone was deleted while in MSP custody in something like April of 2022. Remember? Just thinking, just spitballing with you. That was my initial thought. And did you guys see that Aiden Carney ran into Ben Affleck yesterday on the Cape? Did you see this? Oh my God, hold on. And he got a picture? It's fantastic. Thanks for sending this to me. Hold on. I was like, I was wondering if he recognized him. I was kind of mad. I was kind of mad at Ben Affleck too, because I was like, why hasn't Ben Affleck and Matt Damon spoken out about the Karen Reed case? They're local guys. Like, why can't they speak out? They should be out there, like, using their platform to be like, Karen Reed is free, whatever, hanging out with my homies. Here's the pictures. Here's Ben Affleck. How awesome is that? In a pizza place with his kids. And there he is on the beach. He's on vacation with his kids, and that's why he hasn't been on the air. Yeah, Richard Green could find out when the stuff was deleted from her phone, right? Exactly. It could help her in her civil rights action against the county. The Lexus was a lease and the lease is long over. Well, I don't know if it still technically belongs to her, but she technically, they seized it from her, so they should have to return it to her, and then she has to return it to the leasing company. So that's interesting. Somebody said she's been paying for the car the entire time. I don't know. Cannot confirm or deny. Everyone smash the like button again while we're thinking about it. Helen Frost said, did Lally rehome the phones too? He's sneaky. I mean, Brennan's no longer on the case. His job is done. He got paid. He got paid his $566K and he was out of there. Interesting. Jazzy says they're stalling until Aiden's case is over. Isn't the car leased too? So she's still paying for it? Yeah. I mean, for those of you who don't know, even though you have a lease on a car, you can always extend the lease and you can keep paying until it can be returned. And trust me, they probably want you to. And that car only has however many miles it had on it when it went into custody in January 2022. So it's probably very low miles. Yep. You're right, Jadzia, maybe. Quietly DG. Tom Kokonowski should play David Yannetti in Karen's movie. He's handsome, brilliant, and laid back. Thank you, Melanie, for all you do. Oh, thank you, Quietly DG. You're awesome. Ed Wallace can inspect the car. I don't know if Ed Wallace does like data retrieval from cars. I know he's a forensics genius, but I don't know if he's like familiar with the tech stream data and stuff like that. I don't know. Jojo says also you can kind of use the data server to retrieve the deleted data. Right? Yeah, maybe Welcher and Aperture will buy Karen Reed's car for testing. Well done. Well done. Craftastical. Well done. Well done. Right. Plus, she's going to get dinged for the damage, says Heisenberg, to the car because they took apart that whole center, the whole front console. I don't think insurance would cover that type of damage. No, because I don't think so either. I don't know. She had to pay the car off. Someone said it was cheaper to pay it off than continue to pay a lease. You'd have to buy the car, do the damage. I honestly have no idea what she did with the car, so I don't want to speculate about it. But I just find that to be interesting. All right. I still don't know what that hearing was about. Thank you for buying me a matcha latte, whoever that was. It says just someone bought me a matcha latte. Thank you so much. Linda, thanks for your Venmo. Mo says, thank you for bringing the Aaron Spencer case to our attention. It is an outrage. I just donated to his Give, Send, Go, and I'm sad the total is not higher. Well, when we first started covering this case, it was 13,000. And I think it was yesterday when I looked, it was over 34,000. So she says, all of us Karen Reed and Turtle Boy supporters are so generous. Let's show support for this courageous dad. I agree. It is linked below in the show notes if you can and you choose to. It is for therapy for the daughter and the family and for other things that you can find on the Facebook page to support Aaron Spencer. We support Aaron Spencer page, which is also linked below this video for your convenience. And I don't know what hearing you guys wanted to cover today, but I'll look into it. Make sure you have your notifications set. Make sure you have you're subscribed. Smash it again because YouTube has been really wonky lately. It's blocking people. It's like unsubscribing people. And it's really weird. Galaxy Girl says, it would be cool if Lexus gifted Karen and Kaylee, the niece, the new Lexuses. They would get so much publicity and advertisement. I saw a genius thing that happened yesterday on YouTube. Astronomer, the KP at 2:00 today in Dedham. What are the who are the charges against? In Dedham District Court or Superior? I'm gonna have to check the spreadsheet that Suze has. Check the spreadsheet. If it's gonna be Zoom, I can cover it. If somebody wants to send me the Zoom link, I'll cover it at 2:00. You got to make sure you have your notification set so that I can get off here and get back on and do it. But yeah, nothing would give me greater pleasure than covering that, as you know. Also, Bob Alessi is going to be on Defense Diaries tonight at 7 p.m. Eastern. So when I end the stream, it's going to redirect you over there so you can set a notification for that because you're going to want to see that. And Kimberlina says, I think Karen should get the painted car. They wrecked hers. And Tina says, cover KP, please. I know the channels are interesting enough to watch. Okay, awesome. Let's do it. Let's do it at 2. I just got to set it up and I got to find it. Maybe district court. It's related to the restraining order that Lauren has against Kate Peter, a violation of the restraining order. That could be interesting. I'll find out. I'll go find out right now. Okay. So I'm going to redirect you over to Defense Diaries so you can go back and watch them at 7 p.m. Eastern and see Bob Alessi. And let me see what I can find out about this Kate Peter hearing, Mafia Masshole, and the not so confidential informant. And if I can find a Zoom link for it and we can do it, let's do it at 2. Okay? How's that sound? All right, my friends, stay cool, stay kind, stay classy. If I don't see you soon, I'm going to die. So let me see what I can do at 2. And also, please smash the like button, do all the things that YouTube likes, say thank you to the moderators, and just be your amazing, gorgeous, wonderful selves. And I'm going to see you real soon. Peace out, my friends. Say hi to Bob and Allie for me.